in 522 for 2024, we have the following documents. One, the certificate of urgency dated 2nd of October 2024. It is there, including hard copies.
When was it filed?
2nd of October 2024. This is what was before the Honorable Justice Mugambi.
It was not hard.
We say the issues raised in the certificate and in the petition are so weighty that they needed more than one judge. And your brother agreed and therefore sent the petition and the certificate to the Chief Justice to constitute this bench, which I'm happy was constituted. And therefore, we made it clear for the petition applicant in 522 that we wished to argue this certificate of urgency before a 3-judge bench. And we are here today. We wish to argue that certificate.
Have you received any responses?
Yes, they have filed grounds of opposition, PU, and that sort of thing. They've complied. And my Lord, we are seeking to stop the impeachment in the Senate tomorrow. So we need to be heard today, whichever way this court proceeds to rule.
My Lord, can I make one submission?
So they've got hard copies of this. They are here. These are the ones. What is the one? 522.
Yes. But we had given hard copies.
Yeah, no.
So we have consulted on the issue of the submissions which were made, firstly on consolidation, or the matters which are before us, secondly on the issue of the application dated 2nd of October.
Your Lordship, how about my application? I indicated that I would also wish to urge my application dated the 30th of September. Perhaps you could
Which
see.
orders are you seeking?
I am seeking for conservatory orders as well.
Which kind of consultation orders?
Your Lordship.
See, once we deal with the issue of consolidation, we are filing.
All right, okay. I'll be patient.
Yes. So it seems to us the best to have all these matters consolidated and had together as a consolidated petition. And that is the order of the court. What we will then do is to reconfigure the parties and find out how we refer to them. Judge Mreba will lead us in this process. And of course, by the way, consolidation is only for matters which are before us. We cannot entertain any matter which is not currently before us.
Yeah.
So the 6 matters which were referred to this bench will be consolidated and had together as one consolidated petition. We then now reconfigure the parties.
Thank you very much, Mr. Judge. I hope I'm audible.
Yes, you can hear you, my lord.
Yes, my lord, we can hear you, my lord.
Okay. Now, going by the ruling delivered by Judge Mzambi on the 11th day of October 2024, petition 522 of 2024 was made the lead petition. Therefore, the first petitioner in this series will be the Honorable Gachagua, that is petitioner number 1, and then the parties in 509. In 509, we have 5 petitioners. So petitioner number 2 will be Obuli Namenya. Petitioner number 3 will be Kennedy Karidi Gachagua. Petitioner number 4 will be Dennis Okumu. Number 5 will be Simon Muchangi. And number 6 will be Peter Maina Kanene. Then parties in 537. That will be petitioner number 7 will be Gemawato Association. (528). Petitioner number 8, the series will be John Mugo Kiragu. (525). Petitioner number 9, the series will be Jomo John. And in 506, petitioner number 10 will be Caroline Wambui Mwangi. Then on the part of the respondents, parties will appear as follows. The first 4 respondents in the lead petition, that is 522, will continue appearing as the first to the 4th respondent. That is, the first respondent will be the Speaker of the National Assembly of Kenya. Second is the National Assembly of Kenya. Third respondent will be the Speaker of the Senate. And the 4th will be the Senate. Then we will have Honorable Moses Masika Wetangula as the 5th respondent. Honorable Amason King Jeffa as the 6th respondent. The Honorable Attorney General will appear as the seventh respondent. And interested parties will appear as follows.
My Lord, before you go to the interested party, you've forgotten the Deputy Speaker, National Assembly.
Deputy Speaker, National Assembly.
Yes, yes.
So which file does he appear in? I didn't see any of such party.
Lordship, the Deputy Speaker of the National Assembly appears in E537.
537. E5.
It's still as the third respondent in that matter.
537 is here. Oh yes, we have a third respondent. So this one will be to complete again. Let's have the Deputy Speaker of the National Assembly as the fifth respondent. Then Honorable Wetangula becomes the sixth. Then Honorable Amazon Jeffa becomes the seventh. And the Honorable AG becomes the eighth respondent. Any other respondent we've left out? Okay. Then in respect of the interested parties, they will appear as follows. The first interested party will be Honorable William Samoei Ruto. And it appears like he'll be the sole interested party in this.
The Deputy President.
LSK.
On LSK. In which file does LSK appear?
We are the interested party in the lead file, 522 of 2024.
So LSK becomes the second interested party. Any other interested party?
It's not in 528. There is Mount Kenya jurist.
528.
Yes, ma'am. Yes, ma'am.
Mount Kenya jurist. Oh yes. So Mount Kenya jurist will be the third interested party. Next. Okay. We don't have any energies, so I think we are done with the consolidation and how the parties will appear henceforth.
We thank you. May I now have the opportunity to address the court on my motion? On my notice of motion in 522 for conservatory orders.
We have just a minute.
Well, just a correction on the names. My Lord, your record should properly reflect the parties. When you refer to Honorable William Samoei Ruto, the proper statutory name is His Excellent. So you put HE instead of my Lord, instead of Honorable. My Lord, the same applies for regarding Gachagua.
Mr. Wanyama, I'm bound by the pleadings here, and they refer him as William Samoei Ruto.
My Lord, I'm just mentioning for the record of the court.
The court cannot amend the pleading.
Yes. That's how the petitioner perceives him.
Yes, we have taken the preliminary arguments put forth by Senior Counsel Mitchell and very brief responses which were made by various parties and responses thereto. We recognize that the application dated the 2nd of October 2024 is a very urgent application, and therefore we will not entertain any further discussion on whether or not it should be had. The directions we are making is that we direct all parties to file submissions of 5-page, each to be highlighted tomorrow in the morning at 9. So your submissions must be on file by 8 a.m. We'll give you 5 minutes each to highlight one issue in your submissions.
Well, that defeats the whole purpose of. That defeats the whole purpose of the notice of motion by the Deputy President, because Senate is commencing its impeachment at 9 a.m. tomorrow. And the whole purpose of this notice of motion was to stop that impeachment from commencing. So it's purely academic. We ask that we be heard now so that the record will reflect the arguments of the Deputy President, whichever way this honorable bench will rule. But asking us to come tomorrow at 9 renders our notice of motion nugatory, purely academic.
Malot, if I may.
Yes.
Malot, Jamadi for the State of the National Assembly. Tomorrow 9 a.m. may not be convenient because the Senate will be proceeding with the impeachment tomorrow morning. And in any event, my lord, it is the second respondent respectful position that this application, similar application, has been determined only a few hours ago by your brother, Mr. Justice Gachagua. Those same parties were arguing before Mr. Justice Gachagua, and before your lordship decide whether or not to hear this application, it would be important to have sight of your brother Justice Gachagua ruling of the subject.
The Chief Justice considered that it is right that this notice of motion for conservatory order be considered by a bench of 3 judges, which is why he constituted this judge. Give us an opportunity, and I will be very brief, I don't take more than 15 minutes. That's all. At least let justice be seen to be done.
Is it correct that a similar application was heard and determined by the judge?
One judge. The orders by the Honorable Mr. Justice Mugambi, because of this matter, research weighted issues, they should be heard, the conservative order application, by 3 judges, not 1 judge. And your lordship, I have no doubt I'll be able to convince you to grant the conservatory order. If you give us 15, 20 minutes.
Hello? With your permission, my lord.
Yes, a minute, please.
Hello?
There are somebody was online.
Yes,
there was somebody online before you. Somebody.
Yes. If I may go first.
Well, my Lord, my name is Lampa in petition 525 of 2024. Now, given that Justice Gachagua has already settled the question as to whether the court has impeachment, how did any action on impeachment and whether it complies with the Constitution, kindly allow me to make an oral application. So now that this matter is oscillating between the judiciary and the National Assembly, it is yet to go to the third arm of the government, which is the executive. My Lord, my lady, kindly admit my oral application seeking the following order: that pending the hearing and determination of this petition, a conservatory order issued restraining the President or his agent from nominating and or forwarding any name to the National Assembly for consideration of approval as newly appointed Deputy President. The second, on the ground that the court has determined it has jurisdiction on this issue. The court has expanded, has amended already this matter, has already started to process the various petitions before it. There is no legal order restraining the President or his agent from nominating and forwarding the National Assembly with lightening fee a new DP nominee to the National Assembly for approval if the Senate votes to impeach.
Mr. Lemba, I would suggest that you let us finish the issue before us here, then you can raise any application we listen to you. Because there's an application, that's the 2nd of October 2024. We want to deal with that one first.
Yes.
Mine is also, the petition, my notice of motion is also dated the 2nd day of October 2022. It's in support of that, but it is a notice of motion.
Did you serve it?
Yes. And it was acknowledged, and that's the reason why we have responded to that particular petition.
My Lord,
we have even reported from the advocates from the National Assembly, Mr. Nyamoto, and Bumbo, advocate, by learned senior.
I think for the purposes of order, we cannot at the same time talk about two applications. We will deal with that one application, and if necessary, we will go to the second application. For the time being, we are dealing with the application dated 2nd of October 2024 by Senior Counsel Paul Mute.
Yes. May I address the court, my lord?
yes.
Hello,
My
be
Lord,
very-
with your permission.
Just a minute, please.
Milimo, my Lord.
Yes, please.
Now, my Lord, with the new configuration, my Lord, I appear for the 1st, 5th, and 6th respondents. My Lord, we've had the direction that you've given, my Lord, that we appear before you tomorrow at 9 in respect, my Lord, of the lead petitions application. My Lord, on our part, we will be ready to appear before you, my Lord, in the morning to oppose that application, my Lord.
And that, my Lord, you shall note that in the decision that has just been delivered by your brother Justice Mwita, it had some typographical errors, my Lord, that His Lordship indicated that it will be ready soon. We will be requesting, my Lord, that you grant us an opportunity to rely on that ruling, to demonstrate, my Lord, that the lead petitioner before you is engaging in a process of abusing, my Lord, the judicial process. And that, my Lord, as we appeared before you this afternoon, my Lord, you shall note that some of us, my Lord, appeared virtually, because we know, my Lord, that the matter is coming up only for directions. For my daddy colleague, therefore, my Lord, to seek that we proceed with the motion today is in itself, my Lord, being not only discourteous, but dishonest also, my Lord.
We have considered these submissions, and we must be alive to the urgency of the matter. After we made the elections, Senior Counsel Paul Mwita gave his further views, and we have consulted, and we are giving the elections forward in a few minutes' time.
Your Lordship, we are humbled by the elections given, but perhaps Your Lordship, as you considered the election sought by my senior counsel, there is an application in 528, equally dated 2nd of October, which is looking to address the consequences of the functions that will ensue either tomorrow or on Thursday, that may or may not render the office of the Deputy President vacant. These are very substantive question of should the Senate proceed to impeach the Deputy President, who is a petitioner, number one. What will ensue constitutionally in the absence of the IBC vis-a-vis the nomination that my learned friend Mr. Lempar was addressing? That is an equally important question, Your Lordship. Would seek your indulgence that as soon as senior counsel submits and pens off, that you grant us an opportunity to address you and convince you the reason as to why you need to admit our application and grant the order sought.
That is what I say.
Yes, Your Lordship.
Let's deal with the Senior Counsel's application. After we finish that, if there's any other applications, we can consider it.
I am willing to compromise my application and deal with the application in 528.
My Lord, I'm not arresting your directions. I'm just also going on record. My Lord, and this is now a practical scenario. My Lord, yesterday in petition 550 of 2024, we appeared for 4 hours from around 10 a.m. to around 2:30, hearing the question of conservatory orders before Justice Chacha Mwita. My Lord, the petitioner in that matter is regarding Gachagua. And my Lord, today at 3 p.m., Justice Chacha Mwita delivered a ruling dismissing the applications for conservatory orders. And my Lord, in that ruling, which we don't have the benefit of possessing the physical copy, the judge has said that the petition which he has determined is similar to this one. And therefore, even as you give directions, my Lord, for us, we will be ready. We will stretch ourselves if your directions are that we hear this matter. But my Lord, it is really a process which...
I think there's a good argument in the submission that this is a three-judge bench.
Yes, yes.
And they want this matter to be considered a three-judge bench.
Absolutely, my Lord. So my Lord, I'm just mentioning, as I wonder, that in that matter, the learned Justice Mwita has stated that the issues in that petition, which he has issued an order dismissing the request for conservatory orders, and in this matter are similar. So the learned judge has forwarded the file to the Chief Justice with the direction that the Chief Justice considers it to be forwarded here for purpose of similarity. I'm just pointing out the convergence, my Lord, so that you're able to have a picturesque perspective on the issue. So, my Lord, even if we are ready, even if you direct that we hear this application, just know that, my Lord, we are really stretched in terms of the issues. We are really stretched in terms of time, and even my Lord, our physical ability to stand here and, my Lord, again, argue the same matter which we've been arguing, my Lord, for the last 5 hours.
It applies to all of us. And to the judges. To the judges. May I give Peter Williams some water? If he had any respect for age, he would have perhaps have said that he should be at the board of us.
Are you ready to take directions?
Yes, my Lord.
Yes, we'll give directions on that.
We have considered the submissions made by Council with respect to the application of the 2nd of October 2024, and the following are the directions of the court, issued presupposing that all parties have responded to that application. The bench will hear the application in appreciation of the urgency of the matter, as well as the weighty issues arising, but on very strict timelines, again being realistic about the amount of time that is available. And in the following order, we will allow 7 minutes for each of the petitioners, 7 minutes for each of the petitioners. We will allow 5 minutes for each of the respondents to respond, 5 minutes, and we will allow a further 5 minutes for rejoinder by the petitioners. We aim to render a ruling tomorrow at 8 a.m. That keeps within the timelines that the court has stated for our respective forward submissions.
Lord, can we then have John for 5 minutes? Lord, I'm making a request.
Yes, that one is not a bad one.
Yes,
But he has water.
Lord, I'm making the adjournment because I need to go to the car to pick my authorities. We didn't know that we are coming to make submission, so that we proceed.
Yes, that is in order. We will adjourn for 5 minutes.
But my Lord, we'd like to come to court now that you're proceeding. We are ready to prepare for a mentor. And maybe we'll need about 30 or 45 minutes.
We can hear you very clearly, Mr. Nyamoti. If you can just remain where you are, there's no prejudice. We'll be able to hear you. Okay, we'll give you 30 minutes. We'll give you 30 minutes. All those who want to come to the open court, we'll give you 30 minutes.
Yes, my Lord, I was going to make a similar request. I think we'll be going.
What's the time? We start at exactly 6 p.m.
I abandoned my application because you want the time? Yeah, I have it. So instead of advancing that,